What is the lex Mercatoria? As many definitions as there are writers and approaches, basically there are two approaches: LM as the method, B. LM as a body of legal norms that are created by a trade community to serve the needs of international trade. The latter approach can have three alternative goals. 1. LM merely as a trade usage. 2. LM as an involving autonomous as a national legal order. 3. LM as a customary law. Where do we find the lex Mercatoria? Depending on the approach and goal chosen, the sources of the LM are various. 1. General principles of international contract law. 2. Trade usage. 3. Arbitration awards standards contracts. 5. A standard legal instrument of international commercial law. 6. International conventions. There are two alternative approaches to the compilation of the LM. A. Restatements. B. Creeping codification. Three alternative suppliers of compilations of the LM. Unidroit Principles of International Commercial Contracts. 2. Principles of European Contract Law. 3. The Central Database on Transnational Law. How to use the lex Mercatoria? Basically, there are two alternative uses for the lex Mercatoria. A. Lex Mercatoria as the partial law of the contract either by the contract parties, arbitration tribunals, or national courts. B. Lex Mercatoria as a source for gap filling regarding contracts or the law either by arbitration tribunals or national courts.
When to use the lex Mercatoria? Contracting parties at any time has to place arbitration tribunals. When the contracting parties have to provide either by A. Direct reference to lex Mercatoria, or B. Reference to general principles of international. When the contracting parties have given the arbitrator the powers of amiable compositure, when the procedural arbitration law makes a reference to rules of law instead of rule of law, when the law of the contract needs to be interpreted or gap filed national court. What advantage has the lex Mercatoria to offer? Rules and principles that are designed for the purpose of modern international trade. 1. Avoidance of the conflict of laws jargon. 2. Higher predictability and certainty. 3. Lower transaction costs. A. In negotiating. B. In interpretation. C. In litigation. Uniform law. The uniform law harmonizes regulation of the legal profession, cuts red tape, and creates a single system to govern legal practice. The scheme also promotes informed consumer choice and has strong consumer protection measures. The uniform law's overall objectives are to promote the administration of justice and efficient and legal profession through ensuring legal practitioners are competent and maintain high ethical and professional standards, enhances the protection of clients and the public, empowering clients to make informed choices about their legal options. Efficient, effective, targeted, and proportionate regulation and a co-regulatory framework with appropriate independence for the legal profession.
The principle of international commercial contracts is a set of 211 rules for international contracts. They have been drawn since of 1984 by an international working group of the intergovernmental organization Unidroit, and they were ratified by its council representing 64 governments of member states. As of law, these principles help harmonize international commercial contract law by providing rules supplementing international instruments like the CISG and even national laws. Most importantly, in private practice, they offer a neutral contractual regime which the parties can choose, either by incorporation into their contracts or by a straightforward choice of the Unidroit principles. The Unidroit principles were first released in 1994, with an enlarged edition published in 2004, 2010, and most recently in 2016, including issues relating to long-term contracts. Practitioners who use the principles describe them as a state-of-the-art tool which is particularly useful when parties from different legal systems decide to agree on a neutral contractual regime. International law firm networks have an increasing number of committees concentrating on promoting the use of the Unidroit principles in practice.